case number 108625, State of Kansas v. Dana L. Chandler. Is Ms. Schlimmer in the courtroom?
Justice, she was here earlier.
I think she's coming.
May it please the court, my name is Stacy Schlimmer and I represent the appellant Dana Chandler in this case. May I reserve 4 minutes for rebuttal, please?
Counsel, before you proceed, according to our assistant clerk of the Supreme Court this morning, you missed the what I call the roll call before any arguments were held on our docket.
Yes, and I apologize, Your Honor. There is other counsel, Adam Stolte, on this case as well. He was intending to be here at 8:30 this morning, and he actually has a very bad case of the flu and is not here.
So he contacted you on short notice to ask you to fill in for him, is that right?
No, I was going to argue today. However, he was going to be here at 8:30 for roll call.
Okay. Well, under our rules, you need to request our permission to proceed because you missed the earlier event. So is that what you're asking us to do at this time?
Judge, yes, I would ask the court's permission and forgiveness for not being here at 8:30.
Okay. And I'll follow up by saying when I called the case, you were not in the courtroom several minutes ago. Can you explain to this court why you were not?
Judge, I apologize. I was in the attorney conference room wrapping up my things, watching it live, thinking that rebuttal would occur, and I was going to come in, and when there was no rebuttal, I grabbed my things as quickly as I could.
All right. And you've requested 4 minutes for rebuttal for your argument?
Yes, Your Honor.
All right. You may proceed.
Thank you. As this court is probably aware, this criminal case was before this court a year ago. It was sent back for additional briefing on some issues. This case is a criminal case that involves Miss Chandler in that she was arrested almost a decade after the murders of Karen Harkness and Mike Sisko. Although Miss Chandler was originally spoken with by law enforcement and there was no new evidence against her, she was charged and arrested in basically a medium storm, which involved the then District Attorney Chad Taylor and Chief Deputy Assistant Attorney Jackie Spradling. The case is based on circumstantial evidence. There is no direct evidence that links Miss Chandler to the murders. A jury convicted Miss Chandler for the murders, but not on just the circumstantial evidence, but on the prosecutorial error or misconduct, however the court views the standard of review, and that launched basically a full-blown attack on Miss Chandler's character. So I'd like to start there with the opening statement of Miss Spradling. In opening statement, Miss Spradling referred to a report by Dr. Spiridiglosi.
Was that report part of the state's case, and was it given to the defense prior to the trial?
Your Honor, based on the review of the file, it was provided to the defense. However, there was no notice, not that the state is required to give notice exactly of which particular witnesses it would be calling. There was no notice in the form of a 6455 motion, which there was filings
Well,
prior.
let me understand this. So you had the report, or counsel had the report prior to trial, and wouldn't that afford an opportunity for at least a motion in limine to talk about the contents of the report, what can be talked about, what can't, and address some of the concerns you're just, I think, getting ready to address, but at least minimally the 6455 material.
I would agree with you, but that being said, I don't think that's the focus here. I think the focus is on whether the state had a good faith belief that based on what was contained in that report.
If you were given the report and you had this opportunity, what prevents at least the state in opening statement from referring to it? We anticipate this is going to be evidence in the case, and here's what it says.
I don't believe that it was a good faith belief that this evidence would be presented or would be able to get in at trial. I think when you look at what the statements were made regarding the doctor, the nature of the statements were so egregious that it's hard to believe that any seasoned prosecutor would think that that kind of character evidence would be able to get in at trial. And what made matters worse in this case was the state then called the doctor to the stand. So after the jury heard what the doctor's opinion purported to be, that is when defense counsel did object at the time, and the judge did not let it in because of the 6455 and the character evidence. And the judge specifically said, this was not the contents of a 6455 motion. If the prosecutor had intended to bring that doctor's testimony in, they had filed a motion that listed 8 different specific instances of prior bad acts. That was something that could have been addressed with the court, but it wasn't. And so the opening statement, it has to be made in good faith. The other thing is nothing would have prevented the prosecutor from referring to the report and encouraging the doctor to listen to what the doctor's opinion would be. And that is what you're going to find is motive to this case, or that is where you're going to find information as to the character of Miss Chandler. But the prosecutor didn't do that. The prosecutor called her narcissistic. She said she was of high intelligence, that she had difficulty controlling her emotions. So what we have is, as an attorney in jury selection, what you do is you work on getting out all those biases of jurors. Yet in the very opening statement of the prosecutor, it's hard to unring the bell given the nature of what was said by the prosecutor in those opening statements. Not only did the prosecutor refer to the doctor's statements in opening, then later when the divorce file was entered, the prosecutor went and told the court, we took out Dr. Spirazologi's report. However, the documents inside the divorce file referred to the doctor doing an examination. So that added additional weight to what they had already heard in opening statement. There were, I believe, 2 separate references. One was in the decree itself, where it said that the court was going to adopt the findings of Dr. Spirazologi. I'm just going to call him the doctor right now. So the one was the decree, and then the other one was the actual order, where the court ordered that there be an evaluation done by the doctor. Then, to top it off, in closing arguments, the prosecutor then refers to Miss Chandler being of high intelligence and that she thinks that she is smarter than the law enforcement, and basically that she is smarter than the jury. The problem with that is and I understand that prosecutors can make reasonable inferences, there was no testimony whatsoever regarding the intelligence of Ms. Chandler other than the employer she worked with, who basically said that he thought she was above average intelligence. But if you look back to the opening statement, and it is on page 6 of our supplemental brief, the prosecutor told the jury that the purpose was to determine child custody, but that testing revealed that the defendant has a high average abstract intelligence, meaning she's smart. Also that she's attempted to minimize her problem and had little psychological insight. It's hard not to infer that the prosecutor's statements in closing argument regarding her intelligence went back to the report of the doctor because there was no other evidence that came in. So we have statements that are made in opening that do not appear to be in good faith. In many cases, yes, you may say, as long as it's a good faith that the prosecutor says that, there's just too many other things going on. One involves the protection from abuse. And
Before you get there, I want to stick on what you just talked about. In the closing argument, the prosecutor made the statement that the defendant was highly intelligent, and that was sort of the precursor to outsmarting you and the police and all that. But I'm focusing on the highly intelligent phrase. There was testimony from one witness that she was above average in intelligence, which I don't think equals that. But does the doctor's report, the part you just quoted, is that enough to justify, since it got into evidence, regardless of whether it should or shouldn't have been, is that enough to justify the prosecutor's statement in closing argument that the defendant was highly intelligent?
No, and I'm sorry, maybe I wasn't clear. What got into evidence wasn't the report itself or any of the recommendations were not in evidence. But what was in evidence was the decree that stated that the court was going to adopt the findings and go with the evaluation, the child custody evaluator.
I didn't have that part in my notes about the report. So just to confirm, the only thing we have in your view, to justify the prosecutor's characterization of the defendant as being highly intelligent is that one witness who said above average.
Yes, and I would contend that that's the state's view as well, because in their brief, their response was that because this one witness said probably above average, that was the support that was given for that. The next subject I want to touch on briefly is the protection from abuse. We didn't spend a lot of time supplementing that because it was outlined in the original brief. But what we did do is comb through the divorce file to say, hey, what do we really have here, to see if there was anything that an order could have been. It's almost 1,200 pages of a divorce file, and there's a lot in there. There are only 2 items that even mention staying away from as far as a restraining, let me back up here. There are 2 things that the state argues you could construe a protection order from. The first one is an interlocutory order. Mike Sisko filed for divorce on March 3rd of 2009, I believe it was, and I'll check real quick. March 5th are these interlocutory orders. Interlocutory orders are the orders that a divorce judge, they can do temporary orders restraining people from bothering each other. They can say, don't dispose of your assets. They can put child support in that. That is exactly what this was. It was a temporary ex parte order, meaning Ms. Chandler was never even present when it was signed off on. This is something that is not uncommon in a divorce case for a party to ask for ex parte orders. So the order that was signed off was this ex parte temporary order, had a list of things. One of them was the parties shouldn't restrain each other. As the court knows, a protection from abuse first is a separate case from a divorce case. You file it, it's a separate action. When that is filed, then there is a certain petition and there's a certain order that is granted. So the protection from, or the interlocutory order that was issued in no way, shape, or form was any type of restraining order. And in fact, I don't think that's what Ms. Spradling was referring to when she was talking about the protection from abuse order that she said Mr. Cisco got.
Did the no contact then get adopted after the case was ongoing? That's typically what happens. You're right. Ex parte orders are filed initially to kind of get things set, and then there's a hearing that then determines the parameters of the proceeding, and part of that is taking care of these ex parte orders. What happened? Was there anything about no contact at that point?
Based on my review of the divorce file, it would have been contained in a settlement agreement or a decree likely. I do a lot of defensive work, but I've done my share of family law. I did not see in the file anything that contained a carryover of these ex parte orders when it came to the don't dispose of your property or don't bother each other. And that was the March 3rd. It was 1997. The divorce was filed, and the 5th is when this order was signed.
Before you're out of time, but I want to talk about sufficiency of the evidence.
Yes.
The state cites two cases to argue for sufficiency. One is the Murray case, where the guy's got the cut on the hands, and I kind of don't care about that one. But the Flynn case is causing me some trouble because it seems like there's not much here, but seems like there's more than there was in Flynn. What do you think?
In this case, I think the sufficiency of the evidence, it carries over to the prosecutorial error or misconduct, in that the sufficiency of the evidence alone, I would argue no, it wasn't enough. But I know that there are cases that...
But if the measuring stick is Flynn, and that's what I've
Right.
got to wrestle with that in the analysis that I'm doing here. If that's the measuring stick, does it get above that line, or is it still below that line?
I would say that it does not hit the measuring stick of Flynn when you start to filter out when you filter out what the actual evidence,
Right.
and that's where I'm having a hard time, because there is a lot of evidence that was purported, but then was determined that it didn't factor out. For example, the gas, how she supposedly tracked up to Nebraska, that never got in. So based on what actual evidence got in, I would argue that no.
Well, they've got the woman in Wakini that thinks she saw a black Mitsubishi Eclipse, which is the defendant's car. So if you look at this in the light most favorable to the state, which is our standard of review
Correct.
for sufficiency, that potentially gets her into the state of Kansas, at least as far as Wakini. Now that's about the only thing that gets her in the state of Kansas, but if you get her there, and then you've got strong motive evidence in this case. You've got evidence of obsession, inconsistent statements made by the defendant during the time gap that we're talking about. And then you've got the Flynn case over here. It seems like I'm having trouble saying it's insufficient evidence.
I think if you look at the fact that, at the case as a whole, and the fact that there was DNA traced to the scene that did not match Dana Chandler, that's something else that you consider when you're looking at this. That's the real physical evidence we have in this case. The fact that we do have another party that the defense counseled regarding their motive, and I believe that was the ex-husband of Karen Harkness in this case, and that they didn't do a follow-up on that. I think the mere fact that someone is in Kansas, that that kind of opens the door. Now, granted, she can't. If we believe that this is the Miss Chandler's car that the gas station attendant saw, and that she was coming from another area, that gives you a little bit difference than saying, well, she was in the state of Kansas if she had to come. I just don't think that you're going to rise to that level when you take the contradicting evidence that they talked to Miss Chandler after this happened with an attorney present. She talked to investigators. So she had already been through an examination with them, and the fact that they do have DNA evidence that's linked to the casing in this case.
But counsel, do we get to consider the contrary evidence when evaluating sufficiency? Because then we just look at the evidence in the light most favorable to the state. So don't we really disregard competing evidence?
I don't think the standard is that you disregard competing evidence.
Well, what else do we do with it? I mean,
Well-
how does it factor in when we look at the evidence in the light most favorable to the state? We have to look at those pieces that support the state's case.
Well, you also, I think you have to look at the entirety, but look at through the lens of most favorable to the state. And so, for example, with the ballistics.
And most favorable to the state on the DNA at the scene would be they had somebody over, they left DNA, but it's not compelling.
It wasn't just DNA that they left over, it was actually DNA on the ballistics in this case. So if you look at it in the most favorable to the state, you could say, well, there's other explanations, but I think we also have to be realistic of how we're looking at it through the in most favorable to the state. That doesn't mean that I would argue you don't disregard all the evidence. I think you have to look at it
Totality.
as a case as a whole to determine that.
Okay.
And I know I'm out of time unless,
Do we have any further questions? All right, thank you, counsel.
thank you.
May it please the court, this date appears by Assistant Solicitor General Jody Lipton.
Counsel, you knew you weren't going to get past just
I was
saying your
hoping to
name.
get one sentence out, but yes, Your Honor.
I want to talk about the protection from abuse order. No surprise there. When the state originally argued this case on appeal, you said that the state said that the protection from abuse order misstatement, which you now concede is error, was not error. And I'm trying to figure out how something went from black to white.
And in our brief, I think the misstatement is what we are conceding. She misspoke. I thought that she said that when she was the state was arguing the first round.
Not when you read her brief. You read her brief, no, there's no problem here. It wasn't until a lot of questions came
Okay.
that we finally surrendered more than anything else. But I'm trying to figure out how, from the state's position, the state of Kansas, how you went from black to white on that.
In writing my brief on these supplemental facts, I did look at the oral argument and used any concessions that I thought were made at that oral argument. As she was the trial prosecutor, I believe it was important for me to take that into consideration, which is something that I was not. That was an opinion, or that was, something that I didn't have the benefit of. And so I guess that we conceded based on the oral argument and the
Why wouldn't you
questioning from this
concede it
court.
based on the record on appeal? You looked at I don't understand how that divorce file got into 1,200 pages, got into evidence to begin with, but let's take that aside for a second. I don't see how a trained prosecutor represents that there was a protection from abuse order when there wasn't, and there clearly wasn't. And not only that, but then she said, this was an order from a judge for this woman to stay away from this defendant. And guess what? She ignored that order. And this is what the jury is hearing, and all of it's not true. And that seems to be both a really big problem for the state when the evidence is this thin, and an indication that takes prosecutorial error, now under our current case law, from just error to being misconduct, which we've said we reserve only for really serious offenses.
Sure.
Talk me down off of that.
Okay, well, the comment about the PFA, I guess where I was conceding error is if you're saying that it's a misstatement of the evidence, which I think that's clear, at least from your viewpoint, that there was no PFA, she said the words.
Isn't that your viewpoint too?
If you're considering it to be a misstatement of the evidence that she stated the words protection from abuse order, there was no document called a protection from abuse order in the divorce file, then that would be a misstatement of the evidence, as there was no piece of paper that she could point to support that. However, I think it's important to look at the record as a whole when we're talking about prosecutorial error, and even under Sherman, and know that this was not, I think it was a misstatement, and I know I keep going back to the old standard with ill will and gross and flagrant, but it was simply the title of an order. And she stated in 1998 that there was an order, which is correct, and that it was an ex parte order, just not a protection from abuse order. So she did.
If you take that viewpoint, that that's what she was talking about, then the order was directed at both of the parties, not just her, but she said it was directed at the defendant. So that's a misstatement, even if I give you the other part, right?
Yes. It was to both parties, not just to her. And then I think in combing through some of the other pieces of evidence in the divorce file, it was, I don't remember what the motion or whatever request it came from, some sort of request. So the request was from Mike. So I think that's true. The request to get this order. She didn't
talk about a request from Mike. I mean, she said she had an order that the judge agreed that that defendant should stay away from that victim, and that she also ignored it.
Right.
That seemed to be a pretty big deal.
And if I can point the court to, Mike got a protection from abuse, Mike got a protection from abuse, a court order. If she would have said, Mike got an ex parte order, a court order. There was an ex parte order.
Just fill in the blank, directed
Sure.
at both parties. It doesn't have nearly the impact, does it, as the misstatement?
I don't know. I don't know that I can agree with that. I don't know if the emphasis on this piece of evidence that the court places on it is the same as what the state
It gave
places
the
on it.
imprimatur of the court to her dangerousness. That's what's so unacceptable about it. It implied, if it didn't outright state, that he went to court to obtain an order because she was dangerous, and that what he got was exactly what he asked for, and then she violated it. What he got were some temporary orders that are routine in domestic cases when they're opened, and he happened to be the filing party, so he was the one asking for it, and he got an order that restrained both him and her, which implies nothing about either of their dangerousness, just says when parties are in the process of getting divorces, they should leave one another unmolested. Isn't that true? Isn't that the state of affairs here?
It is, but can I make an argument that what was the evidence presented about the PFA order? How, of course there's an inference of dangerousness if you believe that the jury believes, wow, protection from abuse order, that must mean, or if they knew that that was the same as a restraining order.
Even
yes.
just that the order was directed at her alone.
Sure.
Okay.
But there was no evidence.
Explain to me why this doesn't matter.
On what a protection from abuse order means. That wasn't, at least in my view, the only evidence that about the protection from abuse order was what we've already gone over with. The detective said, was there one issued? Yes. Was it issued against the defendant? Yes. In 1998 or 7 or whatever she said.
That's not what the
yes.
detective said. The detective said, well, and then he came back and took it back.
Yes. And I didn't get there.
Okay.
Agreed.
Okay.
Agreed. He took it back. But there was no harping on, does this mean that she's dangerous? What's the standard that you have to apply a protection from abuse order? What did she do what was in that motion for a protection from abuse order? What were specific instances of her obsessive,
It is
behavior?
called a protection from abuse order,
Yes.
which seems to me pretty explicit that there's some dangerousness implied.
Yes, and we're taking this out of page 24 from a closing argument where there was nothing in the trial to tell the jury the importance of that.
Well, let's put it in
Sort of the point.
context.
There was
Let's put it,
nothing there.
Well, I mean,
let's put it in context.
Sure.
On page 24. The first thing the prosecutor says here in introducing that, you said she didn't harp on it. How else do we know the defendant is guilty? Mike got a protection from abuse, a court order. He applied and said, hey, judge, please order this woman to stay away from me, and the judge agreed. And in 1998, meaning 1 year after he filed divorce, he was continuing to have problems with the defendant not leaving him alone. He got a court order saying she has to stay away. The protection from abuse order did not stop the defendant, though. She broke into Mike's home through a window and looked around. Gosh, when you've got a limited amount of time in a closing argument, that's got to be prime time, if not harping.
and I would have to respectfully disagree, and she did begin many of the paragraphs, and I didn't go through and count, how else do we know the defendant is guilty? That was a common thing that she said throughout the entire closing argument, saying, how else do we know the defendant is guilty? X piece of circumstantial evidence.
If you're going to say to the jury, how do we know he's guilty? I mean, shouldn't you be pretty darn sure that what you say next is true?
There is a duty to know what evidence came in, yes. But this was not the only, I guess my point to that is, this wasn't the only time that she told the jury, how else, and the only reason we know he's guilty, this protection from abuse order. It was repeated throughout her closing argument to link each piece of circumstantial evidence.
Counsel, you mentioned there was nothing in the record that gave the jury evidence as to what this particular order was. Is that true with respect to Mike's alleged motivation for seeking the order? Because I read into this statement by the prosecutor that he was afraid of her. This is her words. He applied, I mean, we've already read this, but I'll read it again. He applied and said, hey, judge, please order this woman to stay away from me. And the judge agreed. Is there anything in the record that would support that inference of Mike's motivation?
Well,
is there anything that was even close to him saying, please order this woman to stay away from me?
well, if the prosecutor was referring, there was also a request for a restraining order. So that's where it gets a little tricky too, is there was a request in 1998 for a restraining order, which the record doesn't show whether that was granted or not granted.
So that's also a statement of facts that are not in evidence.
I don't know if that came in with his attorney, Gordon Rock, in that testimony. I didn't go back and specifically look at that for today, but there could have been testimony on, and didn't Mike request a restraining order in 1998 or something to that effect, but
Well, before we leave this, I don't know whether we were going to leave this or not, but my question is just based on this paragraph that we're talking about, how can we say that that's harmless? You've conceded error, so we're already in harmlessness.
well, can I address prejudice as well?
Well, that's
what
I mean,
it says.
can you
Yeah,
satisfy
okay,
the Chapman
that's fine.
test? Right.
Yeah.
How
Yes,
can you
sorry.
say it is harmless? That was his
If I can get to the second problem, yes. And I've got it somewhere here. I've got a couple of points, and I tried to put them, I think, in the order that was most persuasive for this court. One, the district court has a duty to prevent prosecutorial error on its own. It's got an independent duty to do so. And when this statement was made during closing argument, the district court did not say, counsel, please approach. You've made a misstatement of fact. I believe this is a grave error. You need to correct that. You know, the court has a duty to do it on its own. This got by the district court. This got by, to a lesser degree, defense counsel, because I know this court has said they don't have a
Obligation to object to
yes, or an
prosecutorial.
incentive to do so because they can raise it later, and certainly it's not required. But more than that, the district court didn't say anything. So I think that this court can weigh heavily on that, in that it got past the district court didn't even notice.
But all errors by definition got past district courts. Every time we do anything that reverses the district court, something got by the district court.
Sure.
You can't really mean that, can you?
Well,
That's
I
what
think-
appeals are for.
I think it's a factor to consider, because certainly if the district court would have stopped and did that, and maybe
Then nobody would be talking about this.
well, maybe the prosecutor would have went on and said something different anyway. I mean, went against that court order, but I see your point.
Yeah, I mean, it got past the district court is not very persuasive. I hope you started at the bottom.
Well,
Of
I
your
thought it
list.
was particularly persuasive.
Okay, we have a disagreement on that point.
Yes.
What's next?
Next is the objection, no objection by defense counsel. And I think that's important in this case too, when defense counsel did object on a separate misstatement of fact. Defense counsel did, I believe it was at the break after the first initial closing argument, bring to the court's attention, look, the prosecutor is saying something that Jeff Bailey said or something that the defendant said to Jeff Bailey, and that's wrong. And we need to check that, and that is a misstatement of fact. And the district court was very intent on going back and reading the transcript, finding that to see if it was a misstatement of fact. The court reporter was not able to pull that up, so she looked at her own notes. I mean, they had a long discussion about this misstatement of fact, and the prosecutor's attitude was, I don't want to mislead anybody. I want to fix this.
Well,
So I think
all
you can
that might
use
be relevant if we were trying to figure out whether this was error, whether it actually was a misstatement of fact. But we're not. That's not the focus of this particular inquiry here. You've conceded error. It was a misstatement of fact. And the only question is, what impact did that have on the verdict? That's the only question.
And yes, and I agree. And I think if it had no impact on the district court, and I think if it had no impact on the defense counsel, who did object to a separate misstatement of fact, that has to go to reverse. I mean, that has to be for prejudice. If it didn't, those two people didn't see the misstatement of fact, I don't know that you can say that this had a reasonable probability or whatever the standard is to affect the jury.
Well, here's the standard. I know you know it, but let's get focused back on, instead of prejudice, get focused on our precise standard. You have to demonstrate to us beyond a reasonable doubt that the error complained of did not affect the outcome of the trial in light of the entire record. That is, where there is no reasonable possibility that the error contributed to the verdict. And I guess what we're saying is if a defense counsel missed an objection or the district court didn't sui sponte jump in, how does that fit into that calculus? How does that prove to us beyond a reasonable doubt that the error, which is already conceded, had no reasonable possibility of contributing to the verdict?
That if the two people, I would say that if the defense counsel who knew all of the facts way better than the jury, and the district court who has an independent duty to make sure there is no misstatement of facts, didn't catch this misstatement and didn't bring it to the attention, I would say that is an indication that the jury wouldn't have
Right,
put
the
much
jury
stock
thought it
into
was
that.
true. The jury believed it. That's I don't see it. Your argument cuts against your quest to have us find this harmless.
Well, if I can continue on my quest, I will raise another
Yeah, please do.
point.
Well, I want to bring another point.
Yes.
I want to be mindful of our time, and I want to give you a fair shot at this. But what evidence is there when the prosecutor told the jury that the defendant, quote, drove directly up to Nebraska? After she gets to Nebraska, she turns around and goes home, heading towards Denver. That's what the state of Kansas said this woman did, and I don't find any evidence of that.
And can you clarify, was that an opening statement?
Yes.
Yeah. I believe that the prosecutor had a good faith basis to say this, and going back to what is allowed in opening statement, there's a reasonable latitude to for the state as to what they believe that the evidence is going to present. And the state was prepared to present this with Detective Voley's testimony, tried to. There was an objection, and the district court later held that.
But the question was speculative. It was, well, she could have gone north and gone to Nebraska. That's what the question was, which is just pure speculation. And anybody in law school knows you don't go there. So I don't see how that is a good faith belief to be this certain that this is what you're going to tell. You're telling the jury, this is what the evidence shows. Not that she could have turned left, she could have turned right. I mean,
Right.
You could just as easily say she drove to Oklahoma.
Sure.
But she didn't say that. And she didn't even say, well, she might have. There's an indication in the evidence. She said she drove to Nebraska. And then when she gets to Nebraska, she fills up and then heads to Denver.
There's no evidence that supports that statement. And I don't see why that's not, again, over the line of error and into misconduct land.
Well, and I think maybe that would come with the answer from Detective Oley as well, that was not allowed. I think that there was a good faith basis for the question, because I believe it was an investigative conclusion based on the gas, based on the 5-gallon gas cans, and when she had filled up, that going north would have taken her quickly out of the state rather than going down to Oklahoma or east or west. And that was the fastest way she could have gotten out without filling up. So I think that there was evidence in the route that she took, the fact that she stopped in Waukene and then had to get out of the state quickly without filling up.
Would have been shorter to go straight to Missouri. I mean, it's hard to believe there's a good faith basis that you're going to prove beyond a reasonable doubt your case when you think what you're going to do is ask a detective whether it's possible to go north from Topeka. I mean, I know it's possible to go north from Topeka. You don't have to ask a detective. But it's
Right.
also possible to go east or south. And I mean, this kind of stuff just jumps off the page. And so I'm harping enough. So
Well, and I think it was based on some investigative conclusion made by the detective as to why it was relevant to ask him those questions. Back to prejudice, I'll jump to the jury instructions and go with this longstanding law that the jury is to presume to have followed the jury instructions. And in jury instruction 3, as in most trials, it states that statements, arguments, and remarks of counsel are not evidence intended to help you in understanding and applying the law. Statements that are unsupported by the evidence should be disregarded. And this court regularly relies on that as a part of the prejudice analysis. Also, jury instruction 5 states to consider and weigh everything admitted into evidence and disregard any testimony or exhibit which was not admitted. And I believe that was a preliminary instruction as well. Something similar to instruction number 5.
Does it make a difference when we apply that we're talking about a 1,200-page exhibit? I mean, do we really realistically expect that a jury is going to page through 1,200 pages to verify that the comment the prosecutor made about an order in that file is there?
The way I'll answer that is just that we presume that they followed the instructions. Here I know that we had a very large number of exhibits, I think over 1,000, and a lot of 86 witnesses and a lot of testimony, and a short amount of time to the verdict. So I guess I would just fall back on they're presumed to have followed the instructions. And even if they didn't go through that exhibit, there was at least the testimony from the detective who said there was an order and then there wasn't an order. And then defense counsel said, oh, we'll get back to that, and they never did. So there could have been a discussion by the jury about that testimony. We just don't know.
one of the other problems, talk me down off at this point. The state's case was like a fire hose. It was like a data dump. You put all these witnesses on, all these documents, and you didn't really do anything with any of them. And most of the witnesses are talking about stuff that is cumulative. I mean, it was just a data dump of stuff, which I think makes the closing arguments of the attorneys far more important when the jury's just inundated with a bunch of stuff. You put 12 hours of jailhouse phone calls in it and then didn't play any of them in the entire trial. You played a couple snippets in the closing argument. I mean, that's an example of this. So explain to me why that doesn't enhance the importance of the closing argument by the counsel when the jury has sat here and heard just so much stuff and then trying to make sense of it.
I think if we look at if the PFA was the only evidence of motive, I think it becomes extremely important. Or if this protection from abuse order was the only thing that they had establishing, we didn't have any inconsistent statements. We didn't have any jail phone calls that infer, about the DNA and about the the state's witnesses from Waukene, Kansas. If we don't have those witnesses in Waukene, I think it makes a much bigger deal. I think there's more circumstantial evidence here to motive that makes the PFA comment less important. And that's what I would turn to for all of the other evidence that was about motive by the children, all of the specific instances about her during the divorce case using the child custody to follow and stalk and harass. And if there was none of that, and the only thing focused on this PFA, I think that it would be a bigger misstatement.
What the inferences that the prosecutor made about being highly intelligent, are those reasonable inferences based upon the admitted evidence? And explain to me why it is, and why she's smarter and outsmarted everyone.
Well, I think it is a reasonable inference based on the testimony that this court may or may not agree with on her former employer, saying that she had above average intelligence. And I think
Isn't that it? That's all you had? Yeah.
That's the only testimony we have. And it may be a reasonable inference to think if she had been interviewed and 9.5 years go by and she was not arrested, she could have thought maybe that I don't think that's an unreasonable inference to think she could have outsmarted law enforcement, just due to the nature of the time of the case.
Do we have any more questions of counsel?
Just a quick follow-up, if I may. You were going through lists, particularly on harmlessness, and I just wanted to ask if you got through your whole list.
Well, if I could mention, I've got a few more, but many of those go to it's not repeated or emphasized, it's not indifferent to a court ruling, some of the previous
pre-Sherman factors
we would look at, which we still think are relevant. I would also point to, if we're looking at the record as a whole, the prosecutor correctly stated that he made a request for a restraining order twice in opening statement. And I know that cuts both ways to think, oh, well, in opening statement, the prosecutor said it correctly 15 days before closing statement where she said it incorrectly. But I also think that the jury did hear it correctly twice, at least in opening statement. So this wasn't something that was repeatedly misstated. And I think that cuts against purposefulness, in her misstatements. So if we look at the record as a whole, it was stated correctly in opening statement. And also that this is not just a made-up piece of evidence in the sense that she's not stating that there was some sort of piece of forensic evidence there that wasn't. Or there were orders there. There was a request for a restraining order, and that's where I think it gets tricky. This isn't just something that's made up out of whole cloth the gun that we found there was no weapon. I mean, this was clearly not something that was entirely made up. And then if we look at defense counsel's closing argument, I think this cuts against prejudice as well when, addition to the jury instructions that they were told to look at the evidence that was admitted, defense counsel's closing argument said, look, don't just take the oral claims of the prosecutor and believe them. You've got to look at the evidence and make sure it's supported. Whatever they say is supported by the evidence. So it says, use your own recollection of the evidence. Don't rely on what Ms. Spradling or Mr. Taylor tell you. And I know I also said that statements of counsel are not evidence, but I think the jury did hear repeatedly from defense counsel, don't just buy what they're saying, go back and check. And if you have a duty to check the evidence and make sure what they're saying matches up with the evidence. So I think defense counsel did do a proper job in telling the jury that they have to rely on the evidence. And I would just respectfully request that this court affirm the convictions in this case.
Thank you, counsel.
Thank you.
You reserve 4 minutes for rebuttal.
I'd like to have an opportunity then to talk about, I kind of got into the orders, or what we actually found in the file. The one was the March 5th, 1997 ex parte order. It's important to note that order was never the subject of a 6455 motion, although the alleged PFA of October 1998 was part of a 6455 motion. And the reason that is important is the prosecutor's statements seem to be directed at that motion for immediate restraining order as far as getting a PFA in that October 1998. Now, what's important to look at when you're looking at the conduct of the prosecutor is kind of the whole picture. And there was a 6455 motion, and that was actually briefed by, in the last brief, and there was the list of different items that were brought up. One of the items that was brought up was including on 2 different occasions slashing automobile tires and ripping the convertible top of an automobile. This was actually, the trial court said you cannot get into this. And the state concedes this in their original brief when they talk about the 6455 evidence. They concede that judge said we couldn't get into that. The motion for immediate restraining order that was actually entered as part of the divorce file is found in volume 96, 380 to 381. When the divorce file was entered into evidence, the state proffered to the court that it had taken out Dr. Spirigolosi's report, Dr. I think it was Blair's report, 6455 evidence. If you look at the motion for immediate restraining order, the B specifically says in there, destroying personal property of petitioner's acquaintances, including on 2 different occasions, slashing automobile tires and ripping the convertible top off an automobile. So this should have never even been before the jury, because the judge had already determined that it wasn't going to be allowed under 6455, but it was entered as part of the divorce case. It's this motion that I believe, based on the context of what the prosecutor was saying, was the basis for Ms. Bradling saying in 1998 he got an order. There is no order in file. This motion for immediate restraining order was the subject of the 6455 motion that the state filed. And in fact, if you look at what the 6455 motion outlines, it outlines the specific things that Ms. Bradling wanted to bring into evidence from the respondent's motion for restraining order. If there had been an order, that would have been brought up at the 6455 motion, because the 6455, the judge says, you can get that order in for evidence of her harassing him. So that was the ruling of the trial court at the 6455 motion. So had she had an order, surely they would have brought it to the court, before the court. But they didn't. Instead, what was put in evidence was a divorce file that had hundreds of pages in it that the state proffered to the court that certain things were not contained in that file. Yet, when you look at it, those things were contained. And so then you have to begin to look at the whole picture. Is it just the fact that she misstated simply this chief deputy, prosecutor, who is working a murder case, a cold case that's in the media, that she just happened to couldn't tell the difference between a protection from abuse order that has a different case number, wouldn't even be in the divorce file unless for some reason they entered it for some other reason, or maybe the attorney had it. The other thing that's interesting is that Ms. Bradling never questions former divorce counsel regarding the orders. That's never brought up with former divorce attorney for Mr. Sisko when he testifies. So I think there is an inference here that maybe the prosecutor believed that somewhere out there this order existed. I think in her oral argument before she said she had talked to family members. But that's not evidence. And to come back and say now, well, maybe she misstated it because there were orders in file, there's still, I don't know what orders the state is talking about. There's an interlocutory ex parte order, which does say each other can't restrain, but there is no other order that talks about restraining. There's a motion, and the motion was never heard by the judge. A motion that should have never gotten to evidence because it contained the same 6455 evidence
That had been disallowed.
that had been disallowed. And the state concedes that. If you look in their original brief, which Ms. Ms. Spradling was part of, says that the judge took that out. Didn't let him get into that.
Is your point that that's an indication that we should take this case from error to misconduct? Because the evidence got in. I mean,
Right.
you know, you'll have a
Right.
different day to talk about
Yes.
ineffective assistance of counsel, maybe. But is that the point you're trying to make with all this?
Yes, my position is that Sherman should be the controlling case, and I think this court just had another case that from Sedgwick County that it used the Sherman test on, even though the appellate court, Sherman hadn't been out yet. So I would proffer that we should use the Sherman case. However, I know the state in their brief had said that it wasn't quite certain which standard to use.
I don't think you've maybe followed the question from my colleague. He's asking, even under Sherman,
Oh,
there's error and misconduct. And he was asking you whether you were offering what you just described to support the position that we should regard what happened here as misconduct under Sherman rather than mere error.
I will, with candor to the court, when I was reviewing this, I do. And the reason I want to bring this up is I did not include this in my brief because as I was reviewing the file, for court, that's when I realized, oh, this restraining order actually had this clause in. So, and the reason I'm telling the court that is because I would believe I have an ethical obligation then to bring this to the attention of the disciplinary board or something like that if you're talking about state-based Sherman. I do believe that the fact that the state proffered to the court that they took out 6455 evidence. Now, what they did say is that, which was contained in handwritten notes. So I don't know if that means they only took out that 6455 evidence, but it's apparent that that is what the defense attorney was addressing was the 6455 evidence, and they did proffer to the court that was removed. This is contained in that file. So to me, yes, I believe that they knew that motion for restraining order was in there, or they should have known, and that had been decided to the judge to be inadmissible. So the answer to your question is yes, and that's why I'm just telling the court I'm trying to be have a lot of candor to the court. I have not made any report on it. I would ethically be obligated to, because this has recently, within the last couple days, is when I discovered that the restraining order that was admitted as it was had still contained that 6455, the language that was prevented by 6455. But one of the reasons I brought it up was to look at the total conduct in this case. And I think it's a case where it is so egregious that even under the old standard, I think that Ms. Chandler never had an opportunity at a fair trial from the get-go because of the opening remarks. And then when you compound it with just the character bashing that went on, that even the judge had ruled on several occasions that the prosecutor wasn't going to be allowed to get into certain things because it hadn't been brought up as a 6455 motion. And then with the closing remarks or a closing argument by the prosecutor, I think that this is a case that warrants reversal.
Thank you, counsel. Any
Thank
more
you.
questions? Thank you both for your arguments this morning. The court will take this matter under advisement.